In one of the two most important decisions by the current U.S. Supreme Court, the 40-year-old Chevron Doctrine is gone.
This is Dr. David Shine, and welcome to Business Law 101.
For a business in America, dealing with administrative agencies can be very challenging. These agencies create the rules, enforce the rules, and then their paid employees adjudicate disputes over possible violations of the agency's own rules. If a business is unhappy with the outcome, after exhausting all those internal steps, it can go to court. This is an extremely costly process in itself. Most small and even fairly large businesses cannot afford to do the fight. But even if the business can get to court, it's not usually a fair fight. The reason is something called the Chevron Doctrine. This is the result of a SCOTUS ruling in 1984 in the case Chevron versus the Natural Resources Defense Council. The court held in that case that it was appropriate for the court to defer to the expertise of the government agency when facing an appeal of an agency decision. This is the infamous placing a thumb on the scales of justice. In a 6-3 decision in Loper Bright Enterprises et al. Versus Raimundo, Secretary of Commerce et al., all the conservative justices voted in favor of striking down Chevron. Chief Justice John Roberts stated the majority decision. Courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority. The Chief Justice further explained that agencies are not really supposed to make statutory interpretations because agencies have no special competence in resolving statutory ambiguities. Courts do. A key concept here is that the so-called administrative state is staffed with unelected bureaucrats who are not answerable to the will of the people. The belief is that this ruling will provide a more satisfactory balance of power. This is Dr. David D. Shine. Thank you for joining us for the special episode of Business Law 101. If you've enjoyed this episode, please tune in again.